Great to see that. And I would say we go into the session, and I would again like to welcome Kathleen, Tobak, and Jasper. Thank you for joining us this morning. It's a topic that you are quite that you're familiar with, because you are working with associations on some of those cases, and we look forward to listening and hearing about that. So I would like to give the floor then to the two of you, and thank you for being with us this morning.
Thank you, Kai. So also from my side, welcome everybody, and thank you for joining our workshop on COVID contracts and event cancellations. My presentation will be divided in two sections. First, I will shortly discuss the general legal principles that apply to the cancellation of events due to COVID. Please note, however, that our time to discuss this topic is rather short, so the discussion of these legal principles will be limited to a very general and broad sketch of the basic concepts. But of course, should you have a question, don't hesitate to contact me or my colleague after the session. We will be happy to help you further. Then secondly, I will apply these basic concepts more in depth on a case study of a case that we have handled in our day-to-day practice. And here I will already try to give you an answer to some of the most common issues. I scheduled this presentation for about 20 minutes, and thereafter you will be asked to split up in the so-called breakout sessions, where you will be able to share your findings, your insights and experience with other attendees in this seminar. And finally, we gather together again and we end the session with a Q&A round, during which we, myself and my colleague Jasper, who is here, and we will try to answer to certain of your questions. So I go through some legal concepts with you in a nutshell. It is a basic rule common to all legal systems that contractual obligations between contract parties are binding. This is the so-called principle of pacta sunt servanda, a Latin expression. Whenever a party fails to fulfill its contractual obligations, that party can be held liable. This will generally mean that this party can be forced either to comply his contractual obligations, either if it is not possible anymore, he will be forced to pay compensation. Most legal systems also have one or even two very important exceptions to this principle of pacta sunt servanda. This is the principle of force majeure at one hand and the principle of hardship on the other hand. Very shortly said, based on these principles, if a party is unable to perform its contractual obligations due to force majeure or unforeseen circumstances, that party shall not be held liable. Now, the exact conditions that determine when a situation of force majeure occurs and also the consequences thereof can differ from country to country. Therefore, in an international context, it is always essential to determine which law applies to the contract. And often, contract parties determine the applicable law in the contract itself. This is generally allowed, although there are some exceptions, for instance, for consumer contracts, but those exceptions are not relevant most of the time on the contracts that we discuss today. And then, In the case the parties have not determined the law applicable in their contract, the applicable law will have to be determined based on the rules of international private law. This is a set of rules in every country to determine which law applies to international situations, and an international situation may be the case where a contract is entered into between a party based in one country, a party based in another country, and to make it more complicated, for instance, for services that have to be rendered in a third country. So the rules of international private law for countries within the European Union, these rules have been harmonized in the Rome I regulation. And according to that Rome I regulation, in the absence of a choice of law made in the contract, a contract for the organization of an event will typically be subject to the law of the country where the event organizer has his habitual residence. You can read this in Article 4 of the Rome Regulation. So that article sounds as follows: a contract for the provision of services shall be governed by the law of the country where the service provider has his habitual residence. And this may be annoying when you have not provided for a contractual law choice in your contract. Then it is possible that your contract that you have entered into with a service provider in a foreign country may be governed by the law of that foreign country. And this can be very annoying, especially in case you have a dispute. Then you cannot just go to your legal advisor or your lawyer and ask what is your position in that conflict with your service provider, because your lawyer, who is based in your own country, he does not know the law of the foreign country that is applicable to your contract. So this complicates determining your legal position in the case of a dispute. So the first thing we advise to you while entering into a new contract is to have a look at the law choice and try to have your contract governed by your own law or the law that you are familiar with. So a very important thing to be aware of while entering into contracts, the law applicable to the contract. And then, in addition to determining the applicable law, the parties can also derogate from the legal principles governing force majeure in their contracts. And in most countries that we are aware of, the rules governing force majeure are indeed not binding. For example, the parties can then define the circumstances that qualify or do not qualify as force majeure. Or the parties can also determine what the consequences of a situation of force majeure would be between the parties. Now, when does a situation of force majeure occur? As the specific conditions that determine whether a situation is to be qualified as force majeure differ from country to country, I will not discuss in detail the exact conditions. But in general, and this seems to be most common to a number of countries that we are aware of, you can distinguish two basic criteria to determine a situation as force majeure. First criterion: the change in circumstances is not attributable to the contract party that has to perform. This means that the circumstance should not be caused or could not be prevented by the party who has to perform. And in Belgium, this traditionally requires that the circumstances should be unforeseeable or inevitable. This criterion requires a very factual application, which often makes it quite difficult to apply. And then the second criterion to determine a situation as force majeure is that the change in circumstances makes it impossible for a contract party to fulfill his contractual obligation. Now, when exactly it has become impossible for a contract party to fulfill his obligations also depends very largely on the specific facts and circumstances, and this will require an in-depth examination of the facts of the case. And in Belgium, this criterion is traditionally applied very strictly. It has to be really impossible to perform the contractual obligation. The mere fact that the original obligation has become more difficult or more burdensome to execute is not enough to determine a situation of force majeure. Recent doctrine and case law, however, suggest to apply this condition in a more reasonable way, and as soon as it becomes reasonably impossible to perform the obligation, recent case law accepts that there is a situation of force majeure. Now we have qualified a situation as force majeure. The question is, of course, what are the consequences of such a situation? And also here, the precise consequences of a situation of force majeure can vary depending on the applicable law. And again, the basic rule is also similar in most countries. Once a situation is qualified as force majeure, the performing party shall not be liable for not being able to perform its contractual obligations. This means that this party cannot be forced to perform, nor can he held liable for not performing, so he cannot be forced to pay compensation or damages. Often, the obligations will only be suspended temporarily, and as soon as it becomes possible again to perform the obligations, the party is liable again to perform his contractual obligations. However, if it has become definitively impossible to perform the contract, for instance, an event had to be organized on a certain date or within a certain year of celebration, or the further performance becomes completely useless for the other party, then the party will be released from its contractual obligation. So two situations may be envisaged here: the situation of a temporary suspension of the execution of the obligation, and the situation of a definitive suspension and release from the execution of the obligation. Now, when a contract party is definitively released from his obligation due to force majeure, this also means, and this is also important, that the other contract party shall be released from his obligation in return. For example, if a congress organizer or an event organizer does no longer have to organize an event, the customer also will no longer have to pay for the event. And this can lead to very complex discussions. For instance, what if the organizer has already performed part of its contractual obligations? What if an advance payment has been made? If the performance of the contract has become definitively impossible, it is often a basic premise that everything that has been received for the future performance of an obligation should be returned. This can, for example, mean that part of an advance payment or the whole advance payment should be returned, however, often after deduction of the costs already incurred. So these are the consequences of a situation that is qualified as force majeure. I explained to you that there exists another concept, and that is the concept of hardship and the renegotiation of contracts. Many countries also know this doctrine of hardship. For instance, the Netherlands, Germany, France. This theory or this doctrine of hardship is not yet applied officially in Belgium, but we have a new project of the Belgian Civil Code, and the hardship theory is worked out in the new project of the Belgian Civil Code, which is not yet applicable today. So what does hardship mean? Hardship means that if the performance of a contractual obligation has become substantially more difficult due to unforeseen circumstances, then the parties are required to renegotiate their contract. You see here there are two main differences with the principle of force majeure. Firstly, the doctrine of hardship means that the obligation has become substantially more difficult, while force majeure requires that the obligation is impossible to execute. And then secondly, the doctrine of hardship requires that parties will renegotiate the contract, while force majeure suspends the performance of the contract during the period of force majeure when it is temporary, or force majeure releases a contract party from his obligations when the force majeure is definite. And then the renegotiation of a contract for the organization of an event can take multiple forms. For instance, the parties may agree to postpone the event, or they may agree on extra compensation, or they can adapt the format of the event of the Congress, and they can agree on a payment of the costs already made for a physical event that cannot be used for the organization of an online event. Many possibilities can be envisaged while renegotiating the contract in the framework of hardship. So these were a few words on the legal principles of force majeure and hardship, and the question which criteria should be examined to determine whether there is a situation of force majeure or hardship. And now, as Kai taught already in the beginning of this session, we have handled already a few cases where clients came to seek our advice on difficult situation where they entered into contracts with event organizers and where it was clear that the event could not be held.
I think many changed, cancelled events from last year to this year, and this year we are not too much in a different situation, so we moved contracts to this year. Then now we are not sure what's happening with the contracts that we have made, that we have already moved. How do we handle this? And of course here, and this is one learning, I guess it always is important when a contract is made already, or whether it's done. And I think this is the difficulty at the moment, where we don't really understand what is the best case scenario for us to move forward when we actually come now to the next stage and want to organize a hybrid event, and how do we handle this. And we go into the breakout sessions now, just simply also understanding what are your concerns in terms of moving forward is one question. The other question is, how do you, what is currently your experience in actually negotiating with venues, with partners, with convention bureaus, whatever, to understand what that experience is and what your feedbacks are. Are people flexible? Are they not too flexible? And also, have you maybe found some solutions that, based on Kathleen's case study, maybe some other solutions, or how do you deal with this at the moment? So you'll be assigned in the breakouts now. Kathleen, thank you so much for sharing this so far. I know now why I didn't become a lawyer. So I leave that up to people like you and Sarah and Jasper, that's for sure. So let's see how many people come back.
That
It's
was too short.
huh?
It was too short, too short.
As always, yes. We were saying that it might have been good to actually start this with the breakouts and then get that reflection about the breakouts. So I think there is more to come on this end, but it's great to see you all back. Yeah, most of you. And so the question where I hope you discuss those questions and not any others. What concerns do you have now moving forward? What experiences do you have with negotiation process at the moment? And what solutions have you maybe found to some of those issues that come up in this whole process? So I would then hand that over to MPI Belgium chapter.
I think I can start. We were the first group. So from our side, I can summarize, but Zana, if you want, feel free to jump in. So basically, the some of the, let's say, the biggest solution, how we deal with this situation is, came back several times, is transparency, flexibility, and empathy. So we have to work, let's say, on a good relation with our clients, and but that's not enough. So we should not only rely on that, but also take it one step further and already agree and add in the contract at the beginning everything that we should agree on. Just checking my notes. I think a big concern from Zana, maybe you can explain a little bit about contracts that you have to sign today for an event for next year.
Well, I think our situation is very common to many of you. So we had in the past a physical meeting which we had to postpone twice and then finally turn into a virtual event, and that broke our cycle of events. Nevertheless, our next meeting is in 2022. So my question was what sort of legal form your contract should take if you plan for a hybrid event under the conditions of uncertainty, because right now we may seem that in 2022 situation will be definitely better and we will be able to hold live meetings in one form or shape, but we can easily be in a similar situation next year when everything is uncertain or COVID is still there and it's wave number 7, 8, 9, whatsoever. And you have to proceed planning a big meeting. And if you're planning a big meeting, you cannot really be extremely flexible until the very last moment. So what do you need to put in your contract right now, planning for 2022, a hybrid event, and what clauses should be there in case COVID is still there and you have to turn it back into a virtual meeting, or if your hybrid meeting takes place not in the way you originally envisaged, and let's say your live part is much smaller or completely different. So that's the major question, how to plan your hybrid event under circumstances of uncertainty still. Thank you very much. That's already very helpful. So we know that there is no magic recipe, but those general lines to take, they are very, very helpful. Thank you.
Was it Philip next, or Stephanie, or who wants to go next?
I can go next. I can go next, no problem. We had some very good discussions. I think some of the experiences that we've had in terms of current negotiations have been that venues are currently very flexible, very willing to get things rolling again. So therefore, this is a good time to negotiate. Many, again, are anxious also to get contracts in as well. So it is a good time to look at some of these things. Some of the things that we have looked at are specifically making sure that every eventuality is covered in potential cancellations of part of the Congress. So, i.e., if you have people coming from many different places, it could be that whilst the country of the venue is not locked down, some of the countries of the participants could be. So we've been very keen again to look at how you could offset that in a contract that says if a particular participant's country is locked down, then they would not be able to participate. We've looked at contracts where we have two for this year already, where we actually have a 3-week and a 6-week cancellation policy, no strings attached. So we can take a decision at that point. If we decide to pull it, there are no costs. The other thing we've done is to negotiate and to look at extreme reductions of numbers. So having in the contract the ability to reduce numbers by up to 60 or 70%, and again over perhaps several dates. But again, looking at that as a principle, and that then would enable us to switch to potential hybrid scenario where we've got fewer people actually on site. Other concerns that were mentioned are not all related to the venue, but refunds for participants or refunds of part of the element. So if you start as an on-site event, but later have to convert it, how do you make sure that the participants know what they're getting back, or if they're getting anything back, and what are the likely demands from the participants? You've also got costs involved in that as well. And another element was your contract with your sponsors. That also can be an issue in the event that you have to change the format, or you eventually have to cancel, where you potentially would need to refund that. So again, those were some of the key concerns and key points that came out from our group here.
Yes, thank you, Philip. I guess that also relates to cancellation policies in general for our attendees, virtual, in person. I think there we also need to be a bit more flexible. Last week someone said, Kai, I don't think early bird registrations work these days. I don't know. I don't have the answer, but there's a, makes sense to a certain extent. Is it Bruno?
Yes, thank you. I helped my group to digress a little bit, which is in my habit, but I do concur with what Philip just said, that indeed venues, and this was confirmed, that venues are more flexible these days. That's one thing. I steered our group in the sense that trying to, one step before that, how difficult is it to change your board's mindset and dealing with the, as was said, the optimist, the pessimist, and the realists. What can you really do? I mean, I hear from the people in our group, events were postponed, and then from one April 2020 to April 2021. Very soon that was not possible either, etc. And it's always this perspective of when is all this going to be possible is, I think, an important one. And I try to trigger the fact that it is really linked to the geography where your event was originally planned to take place, or the mindset of where you are. The consensus is this is really still across Europe, despite the fact that the measures in some countries are opening up. As you can see in Germany yesterday, massive departure for Mallorca. It's incredible. I cannot even go to Holland, which is less than half an hour drive from me. So it's very difficult. Moving into hybrid, how can we indeed change those contracts that we don't lose all our deposits? And recuperating, this was mentioned just now in the chat, following up on our session, is deposits from 2019, which have not been, our colleagues here have not managed yet to maybe move those into or make it a floating deposit to a future event. So I don't think there's one solution yet. I think that's what we can say. An aspect we did not cover, and I think this is in addition to what your partners from Korea mentioned. I think an important aspect is to, when you review your contracts, and MPI did a session on that, on really review it with your insurance broker. And if you don't have a broker or you haven't spoken to them recently, call them in and put that together with your contract, with your legal partner, because there's aspects there that change and which might make you spend less money or lose less money for the moment.
Indeed, Bruno, insurance, another big topic. I think that could be another extra session, and I'm glad you internally had that session. And if you are interested to share more of the outcomes with the participants, then you are very welcome to do so. I think we understand we run a bit late. Some people left already, but if you still have 5 minutes, then we would take one more question. And I see Stephanie nodding her head. I guess that means.
Yeah, we did have one question for Kathleen, if it's possible. It was a question from Lynn that who said that moreover, in hotel contracts, you usually, even in general times, you have the clause where it says you have to pay the deposits in time, like a 10%, 20%, whatever, all the deposits. If you don't pay them, then the hotel can cancel the contract on their side. So now the question is, how far can we go into taking this risk right now in this uncertainty? Do we have to pay the deposits as mentioned in the contract, or can we wait a little longer without risking the hotel canceling our event? If that answers your question, or if you...
Yes, absolutely. Thank you so much. I just wanted to add, I think it's a little bit different if you're talking about a hotel and agency. Somebody was talking about working with PCOs, because with a hotel, I'm not saying no service is provided until close to the event, but a lot of what you would be paying for is really for blocking the space for somebody else not being able to, to book the space. But if you're talking about an agency, it's a service, and a lot of the service is actually provided. So, I mean, we're not here to discuss how to protect agencies, obviously, but I do think it's a legitimate concern as well, that if you've engaged, you got staff working, you're paying these people. So how does the force majeure, can you just say, oh, it's force majeure, so everything is reimbursed if you've been working on a congress for 2 years? I don't know if there's a clear answer to that, but I think it's a difficult one. And the client should know about it, because ultimately the client, works with the agency, right? If the agency goes down, the client, it's not to the benefit of anyone, really.
Yes, I remember very well everybody saying last year already, we are all in it together. And regardless sometimes what the legal situation is, I think, or I would hope that everybody plays by that slogan in the next weeks and months to come. we are running late. I apologize. We still have okay number of people there, but I would say we close it here. If you feel we should have a follow-up session on this with more concrete questions that you might have, then we are happy to do that. That's for sure. And if you ever have any suggestions on any other topics or sessions related to legal or not, please let us know, forward those suggestions to us, because this is really how the online session topics and in-person, hopefully soon in-person workshops come about, because we usually have those topics and themes forwarded to us that are of interest to the associations. So with that, I would like to say that we share that information, of course. If you, and I think if MPI agrees to it, we will collect some of the questions still discussed in the breakouts, and we will share that and forward them, and then see how we get some of those answers to you. Please, I think one thing is very clear to me and to the organizations that I work with. We probably need more legal advice more than ever before when we go into new signings, new negotiations. It is probably a clever investment before something bigger happens to us at the very end, because at the end of the day, you know, we are liable also to our members who are asking unpleasant questions when we don't do and decide the right things. But I would like to thank again the Courier team. It's never easy to answer those questions very specifically. We could spend a day on this, and thank you very much, Kathleen, Sarah, Jasper, for your professional expertise. It's very much valued, so thank you for doing that, and hopefully if there is a follow-up session, you'll be interested in joining that and provide that professional expertise as well. Caroline, I think your domestic market is probably one of the first ones opening again. I mean, there are a few things that go right in the UK and England and in your region there. So from that point of view, I think you're probably the first one that starts domestic business again. So that, of course, is great news. I think it would send out a message to the rest of Europe on how that can be done right. And with the advancement of the vaccinations, and also congratulations to that. A lot of countries don't get that right, but it shows that once it is done and done correctly, that you can revive that domestic market again, which for us is, of course, also so important. So hopefully the session brought some answers to you as well.
It's been an amazing session, and thank you for the partnership in it. All of this feedback is so valuable for all of the industry in England, because, you know, we do expect national events to come back as of the 21st of June, hopefully. And but, you know, our international business is so valuable to us. I mean, prior to COVID, conference business was worth 18 billion to the UK. So we really want to see our international visitors come back.
Yes, thank you for that. And I mean, I think generally the industry is not valued enough. I think we saw that throughout, there wasn't enough, isn't still enough lobbying and advocacy for it. For those of you who joined the BF session with David McNair on advocacy and campaigning from the One campaign, as you might remember, they are currently having a fundraising campaign for $100 million trying to raise the money for 1 billion vaccines for the developing world. And the topic of his session was just because we have a vaccine doesn't mean the pandemic is over. And I think that is something we in our industry have to realize and understand, that we are probably not going across the world organizing our events with a couple of thousand people too soon, but most likely we stay in our region, wherever your region might be. So just also from a safety perspective, I think this is probably what this is going to be. And I would wish sometimes that the industry understands that a bit better. At least we can bring our national members, or from a sub-regional point of view, our members to those events. But I think that is something we also need to understand and play safe. So good luck to all of you in arranging, organizing your events. The discussions that you have internally, they are always not easy with some of the boards and secretary generals of you who are not. But I think everybody is in the same boat, and it probably brings in more people into the discussion than ever before. Whereas before we had an event team and they, you know, focus on events. Everybody is brought in now, secretary general, boards, to discuss that, because it is a lot of money that we have or don't have when we do these things right or wrong. So good luck to all of you. Best wishes, and we'll hear each other soon. We are taking a break of 3 weeks with the Association World workshops, because we are finally launching our new website and the community-based initiative in the first week of April. So we are focusing on that, and then hopefully we'll see many of you back. I also want to mention MPI has regular events. You see their MPI website in the chat. I think there's even an event tomorrow and on the 30th, and then the MPI coffee, which is always a great session, on the 8th of April. So have a look at their website and hopefully see some of you there as well. And thank you again to all of you, and best wishes, and stay well.